Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and its honorable court.
Good afternoon. The court calls Parks versus Hermann 241 PA 19. Mr. Melrose.
Thank you. May it please the court, my name is Mark Melrose, and together with my son and co-counsel Adam Melrose, we have the privilege of representing Ms. Parks. I would like to reserve 5 minutes for rebuttal, please.
You may.
The question of first impression today is whether North Carolina courtrooms will be open to stroke patients like Ms. Parks, who are victims of medical malpractice and are deprived of life-changing FDA-approved medical treatment. Will our courtrooms be open to patients who are gravely ill, vulnerable, and have nowhere else to turn before their treatment window closes? Or sadly, as the defense urges, will our courthouses be closed to these patients because, ironically, because of advancements in medical science, we're able to prove their odds at a better outcome are less than 50%. It was August 24th, 2014, 80-year-old Anita Parks was at her home in Highlands. Around 12:15, she started feeling her left arm was heavy. It was unusual. And then her left leg wouldn't move, and she called her family for help. Her daughter, who was a registered nurse, rushed upstairs. Her husband came. Her face was drooping on one side, on the left side. They all knew right then that she was likely suffering a stroke. She was unable to walk. They had to assist her to scoot down the stairs and roll her in a chair out to the car. They rushed her to the only hospital in rural Western North Carolina, which was Highlands Hospital, and on duty was the defendant, Dr. Hermann. They knew, the Parks family, that there was a 3-hour treatment window for medication that could potentially save Ms. Parks. The reason why Ms. Parks knew that is because just 2 weeks earlier, her cousin had suffered from an ischemic stroke, was given this life-saving and life-changing TPA clot-busting medication, and her cousin walked out of the emergency room that day. As soon as they arrived, they placed their trust in Ms. Parks' care in that of Dr. Hermann. Highlands Hospital had a stroke protocol in place. There was TPA, which is this clot-busting medication that was on the shelf in the emergency room. I would like to correct a factual error in the Court of Appeals opinion, which stated incorrectly that there was no TPA available at Highlands Hospital and that Ms. Parks would have had to be transported to another hospital. That appears nowhere in the factual record, does not appear in the record. And on page 57 of Dr. Hermann's deposition, I specifically asked him if TPA was available in the emergency room, and he said that it was. I would like to correct that factual distinction. The evidence before the court is that Dr. Hermann failed to follow the hospital stroke protocol. He breached the standard of care despite pleas from the Parks family. He negligently failed to provide the TPA medication and literally went into another room and went to sleep as Ms. Parks continued to suffer from her stroke. What Ms. Parks lost that night was of real value. She lost the chance for an outcome like her cousin to be able to walk out of the Highlands Hospital. She lost the chance for the normal use of the left side of her body. With modern medicine today, we can scientifically and reliably quantify through admissible expert testimony that Ms. Parks had a 1 in 3 chance of an improved outcome, including up to a complete cure with the administration of TPA within the 3-hour window of the last known normal, which was 12:15 a.m. We know, as the Court of Appeals stated in their opinion, that this chance for an improved outcome had real value to Ms. Parks. We know that a jury in North Carolina is capable of assigning fair compensation and value this harm accordingly. The defense seeks immunity for all healthcare providers who care for the sickest patients in North Carolina who are suffering from conditions from which they are not likely to recover. The defense argues that all these patients should be left without a legal remedy in North Carolina, even though they can prove that their doctor was negligent and that his or her negligence deprive them of life-altering or life-saving care. We are not, in this case, arguing for any relaxation on the quality or the sufficiency of the evidence to prove causation. Ms. Parks can prove by the preponderance of the evidence that Dr. Hermann was negligent. She can prove by the greater weight of the evidence that his failure to provide the TPA deprived her of a 1 in 3 chance for a cure. And she can show to the jury that she had a terrible outcome. Although this is the first time that the North Carolina Supreme Court has been asked to address this issue, this is no longer a novel issue. It has been addressed by the Supreme Courts and the judiciary of at least 41 other states. Of those 41 other states who have considered the question, the majority of those jurisdictions have adopted loss of chance as a doctrine for recoverable harm in some form. The evidence in this case and other loss of chance cases is actually more precise and more reliable than the expert opinions that are commonly admitted upon which juries base their decisions. In the typical medical malpractice case, an expert who's duly qualified is allowed to give an opinion that something is more likely than not to have caused harm. And that opinion is sufficient if it's based upon their training, education, and experience. We don't require every expert in every malpractice case to have the level of scientific certainty and reliable medical and statistical evidence that we have in this case. The harm that Ms. Parks...
Speaking of the reliability of the evidence, you've used the percentage of a 33% chance. What is the marginal or chance of recovery from administration of the TPA in and of itself?
Just to be let me answer that in two ways. One is, as Dr. Knight, our expert, said, the way that it's explained to the patients is they have about a 1 in 3 or 35% chance of an improved outcome. When the doctors tell emergency room patients suffering from ischemic stroke, of that 35%, neither the doctor nor the patient knows whether they are going to be in that category, which is roughly 20% of patients who will recover without any intervention. There's no way to separate out those patients who will improve on their own without medical treatment versus those who will improve with the TPA. And so the number of 1 in 3 is the number that patients understand, the number that doctors use, and then that gets into the defense argument of relative versus absolute benefit. But the identification of the standard of care for stroke patients is that the medical community has decided that TPA is effective, and it does treat the very same condition from which Ms. Parks was suffering, and she said she would have taken it had it been offered. The defendant...
What do we do with, under your theory, what do we do with the risk associated with it?
The risk associated with taking the medication in and of itself?
Yes.
There is a risk. There's a 6.4% chance of a worsening condition with the TPA. I think that gets into the informed consent discussion between doctor and patient. If Dr. Hermann had followed the standard of care, he had a duty, according to the emergency room physicians and standard of care in that community and similar communities, to offer the medication. Part of the information that he had a duty to provide, which he never did because he never discussed TPA with Ms. Parks. He had a duty to tell her that there are risks and benefits with this therapy, just like with many other therapies offered to patients in the emergency room. Ms. Parks testified, and her daughter, I believe, also testified that had she been offered the TPA, she would have taken it. And the reason we know why that's true, especially in this case, is because of the circumstance that occurred with her cousin just 2 weeks earlier and the very good result that her cousin had.
Counsel, you've addressed the aspect of this court's recognition of the novel cause of action of loss of chance. The legislature in this state typically is the entity that recognizes and introduces in our state new causes of action. What would be the primary authority that you feel this court would have in recognizing the new cause of action in this state of loss of chance?
We're not asking the court to do anything with respect to creating a new cause of action, what we're asking the court to recognize is that there is a harm that occurs to patients who are deprived of a substantial loss of chance. If the patient can prove that it's a question really of proximate cause. It's not like we are creating a new cause of action, such as for medical monitoring that they were talking about in the Curl case, or other types of novel theories of recovery. What we're asking the court to recognize as the doctrine is that if the patient can prove, more likely than not, that the doctor's negligence deprived her of that chance that was substantial, we're asking the court to recognize that that makes sense under a standard proximate cause analysis.
Does
We're
that
not
court-
asking, yes,
that
I'm sorry.
currently fit in the rubric of what the legislature has created from the fairly regularly and heavily legislated area of med-mal?
Yes, Your Honor, I think it does. So it's a great question with respect to, and the defense makes the argument that the legislature has stepped into the realm of medical malpractice through their legislation, and therefore the court should abstain and not get into issues related to malpractice. The doctrine of loss of chance has been around for a little over 40 years. And in those 40 years, the North Carolina General Assembly has legislated in the area of medical malpractice several times. While the legislature was legislating, for example, in requiring pre-filing expert reviews, passing laws regarding the qualification of experts, the same or similar community standard, a cap on non-economic damages, and a higher burden of proof in emergency medicine cases, the legislature presumably was well aware of the nationwide discussion about the adoption of loss of chance that's gone on, like I said, in nearly every other jurisdiction. The legislature hasn't addressed the issue whatsoever. By the absence of any legislation, I would contend that they decided they weren't going to address a proximate cause issue. And the reason why they wouldn't address the proximate cause issue is because proximate cause has always been within the realm of the Supreme Court and the common law.
Mr. Melrose, is your argument with respect to the question that Justice Morgan asked you, because I was going to ask something similar, is in essence that we shouldn't be concerned about the fact that the legislature has acted with respect to certain elements of a medical malpractice claim because it has not acted with respect to the element that is at issue in this case?
I think that's mostly true, Your Honor, because
that's better than I usually do. So.
I think that the legislature has taken action in the areas about medical malpractice to, on the front end, eliminate the concern for frivolous cases and to make sure that the experts are duly qualified to testify. And on the back end, they've taken action to put a cap on non-economic damages. What the legislature has never done, despite their ability to do so, is to legislate in the area of proximate causation. And the reason for that is because the judiciary, as all the other states that have considered this, it's all been by judicial adoption and consideration. The judiciary is in the unique position. I'm sorry?
How do we know that the reason that they haven't acted is because they're satisfied with the existing law?
Your Honor, I think it's an inference. Certainly there could be the opposite inference. I think the fact that they have failed to act when this doctrine and this category of harm has been well known, and as the scientific evidence and the medical community has put more and more reliance upon the statistical epidemiology odds that patients like Ms. Parks has, they've taken no action. And so I think that it's reasonable for this court to, I would contend, not abrogate its duty to maintain the common law and to alter the common law as necessary to recognize the advancements in medical science and the reliability and of that evidence in order to maintain the common law.
And I understand that to be your argument, but I think I'm used to causes of action being statutory or common law. You're in essence arguing that this is a hybrid action and we can take action, we can make changes with respect to the law in some elements, but not others?
No, Your Honor, but this is still a common law medical negligence case. It is a negligence case. The evidence that's available in this case is of a higher quality and more reliable quality because it's medical and scientific evidence that can prove that what has been lost here is identifiable. That type of evidence is typically not something that's available to a plaintiff in other types of negligence cases. It's actually more reliable. And I think the fact that this court has taken action, for example, in the Rabin versus the Rowan Memorial Hospital case, and also
and Nelson versus Freeland and others that we're familiar with. I think really the issue here is more what we should do.
I think it's a natural progression, Your Honor, of the maintenance of the common law and a recognition that because of the development of science over the last 82 or 83 years since, well, we haven't talked about Gower versus Davidian, but since that time, there have been dramatic changes in the quality and reliability of the evidence that's available. And we're not asking to diminish the level of proof in order to show that Dr. Hermann was a proximate cause of her loss of chance. We still have to prove that that's more likely than not, that he is the one that deprived her. It's really just a category of harm, but it's something that has tremendous value. And the opposite result would say that even though you can identify this harm that she has suffered, the court is not going to allow a remedy, even though it's provable. And we think that the court should recognize it as an act, something, harm that has occurred that the jury can value and which there should be a remedy for.
Is your argument only applicable to medical malpractice cases or all personal injury cases? We represent Ms. Parks. Ms. Parks suffered a ischemic stroke. My argument today is that the court should consider the stroke case that Ms. Parks suffered, recognize that particularly, and if the court looks at the authority that we provide in some of the other jurisdictions, in the Smith versus Providence case of Oregon in 2017, those are essentially the same facts. Ischemic stroke, they had a wrongful death statute, they considered the common law of medical negligence, and they adopted it. That's all we're asking for the court to do. But I think one of the things that we have to think about, is what is the breadth of the decision that you're asking us to make, and that's what I'm trying to get my hands around. Are you asking us to adopt loss? And first of all, I'm understanding you to say that you're asking that we allow a loss of chance claim as part of the proximate cause component of a negligence claim rather than treating it as a separate claim. The second thing I'm not clear about is the holding that you're asking us to make applicable to all medical malpractice cases and only medical malpractice cases, or are you asking that we hold that this generally is a modification to proximate cause as it is understood in personal injury action generally?
We're asking that this court hold that it's, of course, applicable to Ms. Parks, only to medical malpractice cases with this type of evidence. And let me tell Your Honors, the court, what we think it would include, which is first, that the plaintiff suffers an injury or medical condition that's not caused by the defendant. Second, that the defendant's treatment of that injury or condition is below the standard of care. Third, that the plaintiff can prove with reliable scientific evidence her chances that were lost of a good outcome, even though her starting odds were less than 50%. Fourth, the plaintiff can prove that the defendant's breach of the standard of care approximately deprived her of that life-saving treatment. And fifth, she suffers the bad outcome that the defendant failed to treat. There are other medical cases that we think that would be included within that, but for today's purposes, those are the parameters of cases. Many of the jurisdictions that have addressed loss of chance have focused in on stroke cases because the stroke occurs before the patient gets to the hospital. The damage continues to occur, and it's the intervention that's needed. And if we look at, just to briefly touch upon Gower, because that's been cited over the years. It's interesting, Gower versus Davidian's only been cited by this court, I believe, 8 times and never for loss of chance. It was mentioned in the footnote in De Silva. And the reason why loss of chance is not implicated whatsoever in Gower is, number one, loss of chance did not exist as a doctrine for another 35 years. So we know it wasn't a loss of chance case. The other thing that Gower was, it was a lack of evidence and unreliable speculative expert testimony that the court found unreliable. In the Gower case, the evidence was that the condition from which the plaintiff suffered in that case could not have been altered even with immediate different care. So there's a complete failure of proof. And then what's happened over the years, the dicta in that Gower case about that we cannot decide the rights of the parties upon chance, that's been picked up and we think misapplied over in other decisions, talking and somehow suggesting that loss of chance is foreclosed as a recognition of harm under North Carolina law. And so
you've talked about different states that have adopted loss of chance. Do any of those states have the contrib as opposed to comparative negligence?
I don't think so, Your Honor. I think that there are 4 states. I think 2 have rejected. This court is considering it. And then I don't think the other jurisdiction has taken it up. And I think that contrib is inapplicable to the loss of chance because we know that Ms. Parks wasn't contributory negligent. She got there within
in this particular case. Okay. But if we start talking about there is recovery for loss of chance, wouldn't the flip side also be true that the defendant were there to not a negligence on the part of the plaintiff, more likely than not, contrib, but in terms of the plaintiff, if the defendant can show that the plaintiff in some way contributed to her own injury, again, not in this case, but again, this is doctrinal. If we say the plaintiff is able to show loss of a chance, why isn't the flip side of that equally applicable so that a defendant can show that by plaintiff's actions, although they didn't get to the more likely than not standard, the plaintiff decreased his chance of recovery, and therefore that should work into the proximate cause analysis?
I think if we're talking in terms of medical negligence cases, as my understanding, the only time this court has approved of contributory negligence in medical malpractice cases is post actions by the defendant doctor where the patient didn't follow discharge instructions, could be contributory negligence. But in medical negligence malpractice cases, the harm, either the accident or the medical condition, that's already occurred, and that's not the fault of the provider. And so it's hard for me to imagine a case where the plaintiff could somehow be at fault or a proximate cause of contributing to her own injuries when all the patient does is show up and ask for appropriate medical care. And so I think that...
But the point is doctrinally, you're asking us to adopt something. So there are multiple ways plaintiffs can be contributory negligent in a medical malpractice case. They might have delayed in going for treatment. They may not follow the treatment that's been advised. They may not properly follow up. I mean, there are multiple ways. And the question you're asking us to say, well, the loss of a chance should be compensable. Well, why not equally that if there is an increased or a decreased chance of recovery because of plaintiff's actions, why would that not also fit the analysis?
I think I think maybe that there's a fine line, and I think I understand the question with respect to the jury would be given all the information, competing expert testimony that, because of the plaintiff's actions, perhaps that they had a lesser of a chance, a smaller chance than a greater chance. Maybe Ms. Parks didn't have a 35% chance. Maybe she had a 30 or 25% chance. As long as the experts were qualified and the testimony was reliable, the jury would take all that information into consideration, and the jury then would decide what is the value of the loss of chance to this particular plaintiff. But the condition that the plaintiff suffers from, the illness or the injury, none of that. So in other words, I think the doctors and the healthcare providers take their patients as they find them, and that's the standard of care. The standard of care is only to treat the patient with the conditions that exist right then.
Mr. Melrose, I have a question for you. You said here the chances were, I believe you said 1 out of 3. What if it was 1 out of 4 or 1 out of 5 or 1 out of 6? At what point does it stop being substantial, and who gets to make that decision? Isn't that type of line drawing usually done by the legislature?
Well, not in these other jurisdictions. And I think what would define whether the loss of chance was substantial is the medical community that sets the standards of care. The medical community does not set standards of care for emergency room doctors treating specific conditions unless there is some reasonable, substantial chance of improving the patient's condition. They don't exercise in futility. And so on the one hand, this case we know is substantial. It's another day in another case, perhaps, where somebody might choose to litigate a case where there were just very long odds of survival or improvement. Two answers to that. One is I would ask the court to defer that to another day in another case where it's not substantial. But also, the recovery would be so minimal and insignificant to a patient who has such long odds, let's say 1% chance, that it's hard to imagine that a patient would want to bring such an action, knowing that the jury would be asked to consider the loss of a 1% chance of a cure or improvement.
But what if it's not 1%? What if, like I said, what if it's 1 out of 4? 1 out of 5? You get these close line drawing situations. Is it going to vary from case to case based on the particular illness of the plaintiff?
I think it does. It's an analysis that has to determine, just like we do all the time, we decide what's reasonable, what's unreasonable, what's de minimis, what's significant. And I look again to the medical community. If the medical community has developed a protocol like the stroke protocol to treat a condition, we know it's not insignificant. And so I think that's a guideline for us.
It just seems like there's going to be no more uniformity in medical malpractice litigation if we adopt that type of test. I know you're into your rebuttal argument, so I'll stop there.
All right, thank you, Your Honor. And I'll reserve the remainder of my time. Thank you.
All righty, thank you. Mr. Jackson.
Please the court. It's my honor to represent Dr. Hermann today before this court. The plaintiff, in advancing the doctrine of loss of chance, is really seeking a seismic shift in the law of North Carolina. This is not about whether this doctrine can be harmonized with existing precedent from this court. It is about the fact that this doctrine is actually antithetical to established jurisprudence in this state, including but not limited to the Davidian versus Gower responsibility precedent. This case is also about the fundamental nature of the burden of proof and the more likely than not standard. This case requires one of these standards to yield, existing proximate cause, which in North Carolina is based on the more likely than not standard, and as I will demonstrate, loss of chance is not. Or this new doctrine, this yet heretofore unrecognized doctrine in the state of North Carolina. And it's not hyperbole to say that the law of this state as it currently exists is inconsistent with the loss of chance. The primary proponent of the loss of chance that the plaintiff cites in their brief is Professor King. Professor King, in the article expounding and propelling forward loss of chance, is very candid. He says traditional tort law has to be, this is his word, abandoned, and that the courts have to write a whole new set of rules to implement it. This doctrine, make no mistake, is contrary to the existing jurisprudence of the state as it relates to proximate cause. And it fundamentally challenges the more likely than not standard, which is a bedrock foundation of our civil justice system. The Court of Appeals of Maryland and Fennell, when it rejected the loss of chance doctrine, said, when you strip away its rhetoric to what it really is, damages are really being awarded on possibilities. And that's what the loss of chance doctrine tries to do. It tries to create a rhetoric that shows that it's within the more likely than not standard. But the reality is it is based on possibilities. And when Texas Supreme... Yes,
I'm sorry, counsel. Yeah, I just want to understand your argument here, because the more likely than not means greater than 50% chance, right?
Correct, Your Honor.
The proof is not 100% absolute certainty. It's greater than 50%.
It's greater than 50%, Your Honor.
So we've already drawn, there's been a line drawn already. That is the line, greater than, more likely than not, greater than 50%.
Some infinitesimal amount above 50%, yes.
And Gower, in Gower, the plaintiff could not have established proximate cause under any theory of recovery because the facts of that case were that the plaintiff didn't originally get the treatment for the back injury, but 2 weeks later did get the appropriate treatment and still didn't recover. And so how can we read Gower to exclude this theory now when the facts in that case could not have risen to a level to prove proximate cause to begin with?
Gower has to be, first of all, let's focus on the facts of Gower. Motor vehicle accident, fractured vertebral body. Patient goes into the hospital with the fractured vertebral body, alleges that the defendant was negligent in not timely diagnosing and treating it. And the plaintiff brought a malpractice case against that defendant doctor, and the plaintiff brought an expert witness. And the Gower opinion was very carefully to say, my opinion, that had this case received immediate attention and had that fracture and dislocation been reduced, his chances for further recovery or for perfect recovery would have been much greater. So there were two problems with the plaintiff's expert's opinion in the Gower case. This court in 1937 dealt with both of them. And in dealing with the second problem, the first problem was an opinion premised on a premise that wasn't in evidence. The second problem was the chance testimony. And this court dealt with both of those, first dealing with the issue of the premise that wasn't in the evidence, and then went on to say, and I quote, and he merely says, again, those words, he merely says, meaning that all he's saying is this is a loss of chance. He merely says that the chances for further recovery would have been much greater. And then this court, to make matters clear, goes on and adds 10 more words to that opinion and says, the rights of the parties cannot be determined upon chance. And this court clearly decided that there were two problems with the plaintiff's expert testimony, and both of those problems are binding. And again, this is in a supplemental authority we presented last week, Hayes versus City of Wilmington. When the court actually presents two or more points, and any one point is sufficient to support the decision, but the reviewing court decides all points. The reviewing court in Gowan decided the mere chance point. It becomes precedent in respect to every point decided. So,
but help me understand, if we gave Gower the import that you are suggesting, we could no longer apply the more likely than not standard. We could only allow recovery when there was 100% absolute certainty that the negligence, that a different outcome, an improved, better outcome would occur.
The Gower decision itself is based on jurisprudence that is subject to the more likely than not standard. All Gower said is because the plaintiff's testimony was based on chances, the rights of the parties could not be based on chance.
But if the more likely than not is still a chance, I mean, if you have a 60% chance of a better outcome, there's still the 40% people who won't get that better outcome. So it is still a chance standard. And what it seems to me what we're quibbling over is what does the medical science allow us to say about where the harm actually occurs? And that in 1937, doctors maybe didn't have the medical research and studies and documentation to more precisely say what the chance was. But if in 1937, the standard was more likely than not, we were still working on some chance of a different outcome.
Well, in the civil system, it's always been the preponderance of the evidence, which has always been tipping the scales, the more likely than not. And the Gowan decision, when it used the word chance, is using it in distinct opposition to another word, likely. There is a very clear difference in the jurisprudence between something that is a chance, which doesn't meet the preponderance of the evidence standard, and something that is likely, which is more likely than not, greater than 50%. So I think that language chosen in Gower is absolutely clear when it's coupled with the analysis of the testimony from the plaintiff's expert witness in that case.
And so then what are we to make of the federal court decision, the 1988 federal court decision in Shoemaker, where the court there is looking at North Carolina precedents and saying, well, North Carolina has not conclusively decided this issue. And it seems to me that's also relevant to what information the legislature might have about what the status of North Carolina law is on this question.
So two responses. First, about the Shoemaker case, Your Honor, which was the Middle District of North Carolina. That, first of all, that case has to be put in context. That case was relying on Hicks versus U.S., which is a Fourth Circuit case from 1966. That Hicks language used in dicta substantial chance. 2 years later, the Hicks court disavowed that, and Clark versus U.S. 402 F. 2nd 950 disavowed that language. The Hurley court in the 1990s disavowed that language and said, we are in no way saying that in Hicks, we were recognizing loss of chance or anything less than the more likely than not standard. So when the Middle District looked at and made its decision in Shoemaker, it was basing it on a misapprehension of Hicks. Hicks suggested that there was potentially a theory of loss of chance, but the Fourth Circuit has made clear numerous times since then that that's not how Hicks should be construed. And so when the Fourth Circuit, when the U.S. Middle District Court was reviewing loss of chance in the Gowan case, it did so in that context. As it relates to the legislator's state of mind and why they did not preempt or say something about loss of chance, which I think was the second part of your question, it is fundamentally clear that to prevail in a medical malpractice action, you have to show not a chance, not that there is a chance of recovery and that somehow that chance of recovery is an injury that can be recovered, but you have to show an actual injury, not a chance of an injury, an actual injury, and that more likely than not, the alleged negligence is the proximate cause. That is the bedrock understanding that is taken away from our jurisprudence. And you can see that because over and over again, the Court of Appeals takes the Gower versus Davidian case and says exactly that, says that chance is not enough. You have to show more likely than not.
Are you saying, therefore, Counsel, are you saying, therefore, that the Gower case should be construed by our court to definitively say that the loss of chance doctrine is not a cognizable claim in this state?
Yes, Your Honor. I think the Gowan case does make that decision. And in fact, the Gowan case makes that decision because every jurisdiction that's recognized loss of chance, and again, the plaintiff's leading proponent of it, Professor King, in the article, says you have to jettison, you have to abandon common law principles. So the Gowan case actually does decide loss of chance. Now, in 1937, when the facts were presented in Gowan, it did not have the name loss of chance, but it had all the aspects of it. And it's even very clear from the language of the opinion in Gowan, because not only do they say the rights of the parties cannot be determined upon chance, which means not more likely than not, but a mere chance, which means unlikely to happen. But they go on to say this as well. The plaintiff, having failed to offer evidence tending to show that he suffered any injury which was proximately caused by the alleged negligent act. So if loss of chance is an injury, as the plaintiff proposes to this court, the Gower court rejected it because the Gower court said there was no injury that was recognizable under North Carolina law. This court.
Mr. Jackson.
What's your response?
I'm sorry, go ahead, Mike.
Mayor Justice Hudson?
Of course.
Yeah, it's just a follow-up. Thank you. Counsel, one of the amicus parties looks at Gower in its brief and says that Gower does not represent that there is a recognition that there is no loss of chance doctrine in this state, but that Gower was merely an evaluation of the quality and the sufficiency of expert testimony in that case. And as a result, what was said about loss of chance, as you would represent it, was not really a lack of recognition of the doctrine, but it's more a matter of simply saying that that was dictum that has now metamorphosized into something else. What's your response to that?
Response to that is you have to go back to the text of the Gower opinion, Your Honor. And the Gower opinion, in a sentence with the word "and" in it, deals with the two problems with the plaintiff's evidence. The first problem is the sufficiency of it. That is an opinion premised on a piece of evidence that's not a fact that's not in evidence, which it deals with. And then the court goes on to say, and he merely says that the chances for further recovery would have been much greater. Again, the word chances, meaning something less likely than not. And so I think that, I think to answer your question, Justice Morgan, I think that is the amicus is a misreading of Gowan. You have to read the entire text. Sorry, question.
I have a sort of a simple question. I was trying to ask it before my security team started barking. Just very quickly, even if we were to disagree with your interpretation of Gower, or to overrule it, or to go down the road toward loss of chance in North Carolina, is there any reason that the legislature couldn't then act, should they so desire?
Well, the legislature has been acting in the arena of medical malpractice for 75 years, starting in 1975. The legislature has taken solace and comfort in the status of the law that loss of chance has not been recognized, and given how Gowan was decided and has been interpreted. And to now ask the legislature to act would be, I believe, Your Honor, inappropriate, given that every reason this court has ever given to give deference to the legislature and not recognize a new doctrine or not recognize a new cause of action actually applies to this case. And specifically, there are three of them.
Well, I'm not suggesting that we or you ask the legislature to act. I'm just asking whether, in the event that we make a decision that they think does not accurately or properly reflect the law in North Carolina, they could act to address that, couldn't they?
They could act, but Your Honor, the more fundamental question is should this body, should this court, the judicial branch, act when we know that the legislative branch has expressed a policy preference? And again, if I can sort of get into the three reasons for why loss of chance, even if this court were writing on a blank slate, and I want to be perfectly clear, this court, it's our position, this court is not writing on a blank slate. The Gower versus Davidian, its ensuing law and jurisprudence, the doctrine of stare decisis, keeps this court from writing on a blank slate. But even if this court were writing on a blank slate, there are three reasons that this court should not recognize this doctrine. The first is that the doctrine actually conflicts with and is inconsistent with traditional tort concepts. And that has been something that this court has struggled with for over the last 100 years in recognizing causes of actions or theories of recovery, starting back with Young versus Western Telegraph, which was decided in the late 1800s. And the question was whether physical harm could be, whether or not emotional anguish could be an injury. And it held that physical injury and things like it, which include emotional harm, could be. But this court also struggled with it more recently than the late 1800s, in Azzolino, where this court said that, wrongful life and wrongful birth, even though those are causes of action or theories of recovery or injuries that other states are recognizing, they don't fit into our common law. They don't fit into our traditional concepts of tort law, and we're simply not going to go there out of that respect for the role of the judicial branch of the government. But you compare that, obviously, to Jackson versus Baumgartner, which was only decided a year or so later after Azzolino, when it was a real injury, the medical condition of being pregnant. This court did recognize the cause of action because it did fit within the traditional framework. Loss of chance does not fit within this traditional framework. And here is why. Loss of chance as a doctrine creates this dilemma with the plaintiff who beats the odds. you have the following hypothetical. You have a plaintiff who has a 40% chance of recovery if the plaintiff receives medical care that is consistent, what the plaintiff says is consistent with the standard of care. The defendant is alleged to be negligent and destroys 30% of that 40% chance. But the plaintiff beats the odds. The plaintiff recovers. If the loss of chance is really an injury that this court, that fits within the traditional common law concept recognized by this court, then even the plaintiff who recovers would have a viable loss of chance claim. And the courts that have rejected loss of chance have all focused on this dilemma, this problem created by the plaintiff who beats the odds. And in both the Supreme Court of Nebraska and the Supreme Court of Texas have dealt with this. And they basically say that because of this plaintiff who beats the odds, 40% chance of recovery, alleged malpractice destroys 30% chance of recovery, leaving only a 10% chance of recovery, but the plaintiff still ends up with the improved outcome. If the doctrine is logical and consistent, it must mean that plaintiff can recover. And when the Nebraska Supreme Court rejected this cause of action just in 2017, it said that the real harm in any case is whether the patient ultimately suffers the recurrence or death. Unless courts are going to compensate patients who beat the odds and make full recovery, the lost chance cannot be proven unless and until the ultimate harm occurs. Hence, legal responsibility under the loss of chance doctrine in reality assigned based on the mere possibility that a tortfeasor's negligence was a cause of the harm, which is why this case threatens to upend the more likely than not the preponderance of evidence standard in this state.
So if I can just follow up on that, what has been the experience in the majority of jurisdictions that have allowed recovery for the harm of a less than 50% chance of an improved outcome? How do they handle this dilemma of the plaintiff who recovers?
Quite frankly, Your Honor, they ignore the dilemma. It's only the cases who reject the doctrine, who address the dilemma, recognize it for the problem that it is.
I think maybe I was asking a more practical question. Has it become a problem in those jurisdictions?
Well, I have no idea if empirically it has become a problem. There are no reported cases dealing with that. But the hypothetical is more than just a merely interesting hypothetical. The hypothetical identifies the nature of the alleged injury that is loss of chance, because the hypothetical shows the real root of the problem behind loss of chance. Because if in that plaintiff who beats the odds, if loss of chance is compensable under the law, and there is not a rational explanation for why the plaintiff who is fortuitous enough to beat the odds and recover, even with the 10%, why he or she doesn't recover, if the courts cannot articulate a reason other than, well, she didn't have the outcome, then there is no rational basis behind the doctrine. And while it is a problem for the jurisprudence if it empirically happens, as Your Honor suggests, it's more importantly shows what is fundamentally wrong with loss of chance as a, quote, injury or theory of injury. Because there really is no injury. And again, the Court of Appeals of Maryland.
Let me ask a follow-up about that. Wouldn't you have a pretty good argument in the trial of the case, given that hypothetical, that there really was no loss of the chance if the patient beat the odds, and that therefore that shouldn't go to the jury anyway?
Well, and that's exactly why that loss of chance is not an injury, because if it is an injury for the patient who did not beat the odds, you can't say that the patient's injury who did not beat the odds was more likely than not caused by the physician, because more likely than not, it was not. It is about the essence and nature of the injury itself. And so the very problem you point to, which is if the trial court were to say, well, I'm not going to let that go to the jury because that plaintiff who beat the odds didn't have an actual injury. That's the very heart of the problem. Loss of chance isn't an actual injury for the patient who is fortunate enough to beat the odds, or for the patient who is not fortunate enough to beat the odds. It is not an injury. And
Let me just real quickly about the loss of chance here. Should the court consider that there's a 20% baseline recovery, and is the loss of chance here for failure to prescribe this medication simply the 13% that it would have enhanced recovery? Can you speak to that, please?
yes, Justice Newby, absolutely. The evidence based on the plaintiff's own expert, and the procedural posture of this case is that the plaintiff's expert, Dr. Knight, was designated and deposed, and following his testimony, we stayed all other discovery, including any obligation on behalf of the defendants to designate, and agreed to proceed forward with the summary judgment motion because of the issues raised by Dr. Knight's testimony. So all that's before this court is Dr. Knight's testimony. And the undisputed conclusions from Dr. Knight's testimony is that it is the absolute benefit of TPA is 13%. And we know that because, as Dr. Knight agreed, the studies for TPA they had a control arm and they had a treatment arm. In the control arm of the placebo arm, 20% of the people received an improved outcome. In the treatment arm, those people who received alteplase or TPA, there was roughly 33% of those improved. So, which is extremely important, obviously, to understand who's just going to get better, notwithstanding treatment, and who isn't. And so that difference, 33 minus 20, is the 13% absolute benefit of TPA. And as set forth in our conditional petition, we are asking this court, if you decide to reach the issue of loss of chance, that you can decide that the facts of this case do not adequately present it for recognition or non-recognition, because that absolute chance of improvement of 13% is not substantial and therefore should not be recognized.
Well, what do you do with the 6.7% risk of adverse impact?
Well, and the answer to that question, Your Honor, is, quite frankly, in the context of a judicially created doctrine loss of chance, who knows? That fact, that question exists, is exactly why this should be left to the legislature. Because how does the fact that just over 6% of the patients have go from an ischemic stroke, a clot that is causing injury, to a hemorrhagic stroke, a bleed that is causing injury? How do you factor that into that? Well, just simply recognizing loss of chance leaves the trial courts without any guidance for how to deal with that issue.
Let's go back to the. Go ahead, Justice Earl.
Please, go ahead.
I was just going to ask for your response to an answer that Mr. Melrose gave me in my discussion with him about the role of the General Assembly in the area of medical negligence. If I understood his argument, he said that we should feel free to address proximate cause related issues because the General Assembly had not acted on them in Chapter 90. And I always like to get both sides of argument so I can appropriately consider both points. What's your reaction to his contention that no, we shouldn't interfere with the standard of care issues because the legislature has prescribed those, but we should feel free to use our common law authority with respect to proximate cause, since the legislature has not specified proximate cause as a statutory matter?
Justice Ervin, the first is that you have to start from the foundational assumption that when the legislature acted in 1975, which is when it began legislating in the area of medical malpractice, it operated from the assumption, and the correct assumption, that the civil justice system for malpractice cases was more likely than not the preponderance of the evidence, and the plaintiff had the burden of the proof. There was no reason for the legislature to even consider entering into the proximate cause arena, because it understood the status quo. It understood the status quo that a doctrine like the cause of the loss of chance cannot exist within the status quo. So it would have had no reason to act there. But what it did do is when it saw issues related to how the courts were dealing with issues regarding standard of care, it did act. So the only reasonable inference to draw from that is to say that the legislature did not intervene because it understood the status quo to mean that the doctrine of loss of chance would not be recognized, and therefore there was no purpose, no reason. It would be completely extraneous for them to intervene because they understood the status quo and didn't need to, but they clearly aggressively legislated in that area, establishing the public policy. And a public policy that this court recognized going back to Black versus Littlejohn based on the 19-
I just, I know your time is limited, but I did want to follow up on a question that Justice Newby was asking about the 13% being an absolute benefit and then a 6.7% of adverse impact. And I am just trying to understand when we are applying the more likely than not standard, which is a 50% or better, all of those treatments also have some percentage risk of complications, adverse. I mean, every time you have a discussion with your doctor about informed choice, he tells you all the risks of a procedure. So in every medical situation, there's some risk of an adverse impact. And in the more likely than not standard, we don't somehow deduct that percentage from the 50%, do we?
We don't, but because I would contend that's part of the all or nothing approach, which has been described as the traditional tort process, which is if you can show that more likely than not, even if that treatment did have a side effect, you still get 100% of the recovery because that's the balance that has been made by the civil justice system for the preponderance of the evidence for the more likely than not standard. But when you flip that on its head and permit recovery based on a mere chance, well, then you have this very interesting situation where you only have a 13% chance of an improved outcome, but a 6% chance of a worse outcome. So what is the value of not receiving that medication if that really is the injury? Our position is it's not the injury. I'm sorry, Justice Searles. I'm happy to answer your question, but
Thank you.
Thank you.
Thank you, Mr. Jackson. Mr. Melrose, rebuttal.
Thank you, Your Honor. Let me jump through a few things quickly. Mr. Jackson talks about the traditional aspects of our tort law, and it serves more than one purpose. One is compensation, and another is deterrence. And Harris versus Cheek talks about that as being a fundamental principle of our tort law. Adopting the defense's position and not recognizing loss of chance does create complete civil immunity for every healthcare provider who treats a patient going in for the treatment stands less than a 50% chance of recovery. It includes heart attacks, it includes AAA abdominal aneurysms and many other conditions. We're not asking to reduce the burden of proof. We still have to prove that more likely than not, the negligence and violation of the standard of care of the defendant doctor deprived the patient of the life-saving treatment. To Justice Hudson's question about could the legislature act? Absolutely. If this court engages in modification and alteration and maintenance of the common law, and the legislature decides that as a public policy they disagree with that maintenance or alteration, then they simply pass a statute. And that can be done. And I go back to the fact they have never legislated in this particular area of proximate cause in negligence cases like this. Mr. Jackson says that what Ms. Parks suffered was not a real injury. Well, to Ms. Parks, and the Court of Appeals noted, it had tremendous value. To be able to have that chance to walk out of the hospital had significant value. A jury is perfectly capable of assigning fair value for that harm. The next is, the argument is that she didn't suffer an injury and that if she recovers, wouldn't she still have a claim? And conceivably, technically, yes. But what she would be entitled to would be nominal damages. A technical wrong. She was deprived of a treatment that made no difference. That would be a technical wrong. In our case, though, and as we ask this court to adopt the loss of chance doctrine of harm, the patient needs to suffer the exact same harm from which the defendant, if he complied with the standard of care, could have prevented 1 out of 3 times. just a couple other points that I didn't mention earlier. One is the whole line of cases in White versus Hunsinger and all those from the Court of Appeals that talk about what I say is the misapplication of Gower. Many of the cases that picked up on that dicta that the parties' rights can't be decided by chance, those are wrongful death cases. This case is totally different than a wrongful death case, which statutorily the plaintiff must prove that the patient's death was caused by the defendant's negligence. So there has to be that causation in wrongful death. We don't have that, and it's not necessary for this doctrine. I think what Justice Earls, what you had mentioned with respect to Gower is perfectly true, that Gower couldn't have decided loss of chance because it didn't exist. TPA didn't exist. The scientific evidence didn't exist. So it cannot be precedent for this court, which has cited it, but never for that principle, only 8 times over 83 years. Thank you very much.
Thank you to Mr. and Ms. Melrose and Mr. Jackson. Madam Clerk, would you recess us?
Oh, yes, oh, yes, oh, yes. The Supreme Court of North Carolina is in recess. God save the state and this honorable court.
I guess there's no